We continue then with our breakdown of today's revelations in the Pretoria High Court with Kelly Khumalo's lawyer, Magdalene Moonsamy. Magdalene, good evening and thank you very much for your time and joining us tonight here on In Focus. It is alleged that your client to have been implicated in the murder of sons of Meyiwa by a lawyer representing 4 of the 5 accused. Is this an allegation that your client was expecting, hence sending you to court to sit in?
Absolutely not. I think the intention, the first thing, thank you for having me, Thabo, and to those who are also watching. I think the intention is to understand what a watching brief is. A privilege that was awarded to Advocate Teffo when he was watching brief of the Meyiwa family and subsequently became defense for the suspects accused 1 to 4, which is a major contradiction in itself. Notwithstanding the fact that there is another watching brief for the purposes of the family of the deceased, the late sons of Meyiwa. Now, mine was as watching brief 1 for my client, but secondly, her daughter is also the daughter of the deceased. So I think we need to clarify the contradictions in terms of the intention. There was an application that was made by myself to the prosecutor as well as to the registrar, and my application was approved. There was no issue until, and let's go into the history of the situation, which is a brief one in the first instance, when there was an allegation that I was making the defense uncomfortable, myself making the defense uncomfortable. Secondly, that I was intimidating the defense. Thereafter, there was intimidation against myself and my client. Now, remember, in October 2021, there was an alleged case that was brought on defeating the ends of justice. Understand what my client has been going through since the passing of the father of a child. She's been going through the court of public opinion. And of course, it is her right. It is her legal right to exercise her tenacity to be able to be represented so that the truth does reveal itself. Yeah. She's also a victim in the matter. Yeah. She was a victim of robbery and assault, and that is count 3 on the charge sheet. Now, the issue that is raised about defeating the ends of justice by Advocate Teffo during the calling of my release for the interim is based on a charge that was never brought to the attention of myself nor my client. This is a history that has been ongoing where Advocate Teffo at one point whilst in Sun City prison contacted me insisting that my client hands herself over to the police. Now, one thing that we must bear in mind is the narrative that is being projected is one that we're not going to stand by and have our hands folded when we know that there was no charge.
All right. So will you be making formal submissions regarding the allegations? Yes?
Absolutely. Look, we're absolutely making formal submissions. This intimidation that is ongoing against myself and my client and the public persecution is something that we need to understand. You don't raise an allegation of your client pull the trigger by mistake. Now, that is something we need to know who's the eyewitness. We know that in the law of, in criminal law, it's based on fact, it's based on evidence that must be tested. And when we understand what it is that is unfolding in court, the biggest curiosity that poses itself is my intimidation of a defense attorney, the defense for the accused, and how does that then result in circumstances where we cannot be represented? My client, her child cannot ensure that those who are accused are brought to the book. Remember something, Thabo. You may not know this. The accused who are in the dock have not been brought before those who were in the house on the day of the robbery and the murder to identify them. That by its very nature is a circumventing of the process.
So who identified the accused?
They were identified by the police. They were not identified by those in the house.
So those in the house never saw the accused?
They never were called to an identity parade to identify them in a proper procedural process.
So your client, I don't know if you can give me an answer to that. Does she know any of those in the dock, any of those 5 accused? Has she seen them before? Can she say those were the people who were in the house who robbed and killed Senzo Meyiwa?
Look, we have not had the discussion in as far as identifying them because of the following reasons. They were identified in their statements. So in the statement has the value of what was seen and what transpired. So the dependency on the identification by those accused of my client rests on their statement of what was seen by the individuals in the house on the night that this crime occurred.
Now, is this allegation, does it change things in any way for your client? Firstly, does she feel prejudiced in any way by these allegations that were raised today? And secondly, does your client now become a witness in this trial? Does it clear that for you?
Thabo, we've been saying this consistently. Apart from cooperating and complying with the requests of the NPA, the police, all stakeholders that have been involved, we are waiting for our day in court. There is no greater moment than now, with such an allegation, vexatious as it is, premature as it is, to question an investigating officer regarding an eyewitness who will say this. It's not probable. The state should have been able to place its case where those who were in the house verify their statements, and after their statements are verified, then corroborate that with evidence, and how that evidence would then lead to that, or how it would make the nexus. So there's no way that, look, my client is definitely prejudiced publicly, and this has been going on for almost 8 years. So understand why my role is not something that's new as her attorney. My role has been there since the onset. Now, the difficulty that we face is that when you are constantly under the scrutiny of the public in a manner in which you are becoming the scapegoat for the defense, the same defense who was the watching brief for the family of the deceased, we find ourselves in a conundrum in questions and ask ourselves then, are we busy troubleshooting opinion makers? Is this a courtroom that is exercising an act of sensationalism, not on fact, on assumption? We cannot wait to hear that eyewitness evidence. We want to know that, and we want this also to be known, this defamation, the borderline defamatory character, the character assassination not only of my client but myself by Advocate Teffo, which has been brought to the attention of the court, of which we are not going to stand back and be shaken by, because we have been requested by the NPA, the state prosecutor, sometime in March, April, early April, just before the beginning of the trial, for a consultation, of which we conceded. And 24 hours prior, or I would say 24 hours or just the day before, we're told there's no need. We were informed that our client may not be called as a state witness, and we said we asked for reasons as to why. And then we were told that she will be called as a state witness on the date that I was asked to be released from court. So we are not in any way feeling any kind of pressure in respect of, the outbursts and the sensationalism that comes from Advocate Teffo. We are not going to be intimidated.
So two questions then, Magdalene. What is the status? Sure. What is the state of your client now? Is she a witness according to the state? Has that been confirmed? Is she going to be a witness in this trial?
That was confirmed to me on the 23rd of April, if I'm not mistaken, on the date that the court asked for me to be recused for the interim. So that was confirmed that she will be called in as a state witness, yes. Number
2, will you be taking action? You mentioned the situation of a defamation of character for yourself, but also for your client. Will you be taking legal action on that?
I must confirm the following. We've remained quiet for too long, allowing the law to take its course and respect the judicial process, which is why we anticipate that the court will test evidence. However, this silence is going to be broken because we cannot allow ourselves, especially my client, her children understand Tabo have to go to school and have to face some kind of information that they are collecting from news, etc., about their mum. There's endangerment involved. I was told by Advocate Teffo that I'm exposing myself to danger. And then I was told in open court, well, in my absence once, and then when on the application for my recusal, when it was denied on the Friday before the Monday, when it was then reconsidered by the court, that I am making them uncomfortable and causing intimidation. Those are things I can't stand by and allow. I am an officer of the court. My client is a citizen of this country who has been subjected to extreme public persecution, notwithstanding those that do love her. But this isn't about that anymore. This is about protecting the integrity, the reputation, and ensuring that our client is able to speak in terms of the version of events that transpired. And what we are hearing about contamination of evidence and all of these things are things that should be raised and asked in respect of what transpired in a house, and you can see the size of the property with many adults in it. So for me, yes, indeed, we will be having a consultation and we will decide on the way forward and the steps that we are going to take. Because we have been intimidated far too long by Advocate Teffo, and this now Advocate Teffo suggesting that his clients are being scapegoats. We can throw that right back at him, that our client is being a scapegoat.
Have you had consultations with Advocate Teffo?
Advocate Teffo contacted me on the day of an accident. Thursday, I had an accident. It was very coincidental that he contacted me at 11:08 via message to ask me how to say hey, and subsequently called me. I gave him permission to call me, and I explained to him that, look, I'm not going to stand back. If you want to have a discussion with me, we will have a discussion when we understand what the grounds of your constant intimidating tactics are in terms of a case which was never brought before the court, in terms of your allegations against our client. Give us proof. The first time that I attempted to he contacted me whilst he was in prison. I requested him to send me an email. It's quite funny, actually, because I thought he was on holiday in Sun City, not realizing that he was in prison in Sun City, insisting that I hand my client over to the police for reasons that I could not get on email, of which I found to be disconcerting. And thereafter, he requested such, and I said to him, when I'm back in court, I will then engage you. We remain fraternal. However, if you are going to place and level allegations against my client that cannot be verified, then we will find each other in court, and we will be able to then deal with the issues at hand. I do not see what it is that Advocate Teffo would want to discuss with me if it's not brought to open court. I don't believe in gossip. We are in a court of law. That's our responsibility. Fact, not assumption. So we rely on facts, and on any assumption or allegation that is raised, we will make formal submission to that effect. I will consult with clients, and then we will be able to present formally a statement in that regard to the media.